If you've been in a car accident in Georgia and your insurance claim just got denied, don't panic, but don't ignore it either. Insurance companies deny valid claims all the time because they're hoping you'll just walk away. But here's the truth. You've got options, and if you act fast, you might not just reverse the denial, you could come out with more than you ever thought was possible. I'm Peter Geraci, a Georgia personal injury lawyer, and in the next few minutes, I'll break down exactly why these denials happen, what Georgia law says about it, and how to legally fight back. Now, let's start with the basics. Insurance companies deny accident claims for all kinds of reasons, and a lot of them are strategic. Here are the most common ones. They claim you were at fault or partially at fault. They say your injuries aren't related to the accident. They argue that you waited too long to seek treatment, or they cite some technical issue like policy exclusion, lapsed coverage, or some missing document. And here's the truth. Insurance companies don't make money by paying out claims. They make money by delaying, denying, and minimizing payouts wherever they can. Even if your claim is 100% legit, they may still try to deny it just to see if you'll walk away quietly. So you've gotten a denial in a case. Now what? In Georgia, you're not out of luck. You actually have a few options. So one of your first options is to appeal the denial directly through the insurance company. And usually the way they're going to do that is either by escalating it to a supervisor or submitting new evidence like additional medical records, photos, or any other reports that you may not have included initially. The second way to really appeal it is by filing a complaint with the Georgia Department of Insurance. If you think that the denial was unfair or in bad faith, this can put a lot of pressure on the insurance company to pay when you file this complaint because the Georgia Department of Insurance is meant to prevent insurance companies from acting in bad faith when handling insurance claims. And then the third way to do this is by filing a lawsuit. And this is where I come in. If the insurance company refuses to do the right thing in a case, what you can do after you get a verdict against the other person is sue the insurance company directly for a breach of contract and a bad faith failure to settle. Now, if your claim was denied without a thorough investigation, that's a red flag. Insurers are required to conduct a prompt, fair, and reasonable investigation before denying a claim. So if you run into that situation, make sure you hire a lawyer immediately or file that complaint with the Georgia Department of Insurance. Now, Georgia law is here to protect you, the policyholder, but that's only if you know how to use it. Like anything, if you don't know how to use it or if you're not aware of it, it doesn't really serve you. Under Georgia law, if an insurance company denies your claim in bad faith, they can be ordered to pay the full value of your claim plus additional penalties. And those additional penalties include court fees or even your attorney's fees if you hire an attorney. But to prove bad faith, you need to show that one, that the claim was valid, and that two, that the insurer had no reasonable basis to deny it in the first place. Now, it's a high bar, but when it applies, it can flip the pressure onto the insurance company just like that. Bad faith scares insurance companies. It puts them into territory where they can't really calculate their risk as easily as they would if it weren't a bad faith situation. And the reason for that is once you're in bad faith territory, that allows you the benefit of going beyond what's just listed in the policy documents, in the coverage documents. Instead of your case being limited to just the minimum coverage, which is $25,000, when you're in bad faith territory, you can ask for up to $1 million or $2 million or $10 million, depending on what the real value of your case is worth. Here's the thing most people don't realize. Insurance companies have lawyers. You should too. They're banking on you being confused, overwhelmed, or too tired to push back, or frankly, just afraid to hire an attorney. But when they see you're represented and that you understand your rights, suddenly those doors that were slammed shut at the start begin to open up again. I've seen clients go from completely denied claims to six-figure settlements, and not just low six figures. We've seen them up towards high six figures, even seven figures. And the reason for that is because we understand Georgia law. We know how to apply pressure. We know how to prove liability, and we know how to call their bluff. If your claim was denied, here's what you need to do immediately. Get everything in writing and request a written explanation for the denial. It's unlikely that they'll give you an explanation, but it doesn't hurt to have that. If we're able to get that information, it really helps build the bad faith case later on. Make sure you collect your records, your medical reports, police report, photos, any witness info. Make sure you have all of that organized in a folder, online, or a physical one. Don't give up. A denial is not the final answer. It is usually just the first step. And finally, just call a lawyer. The earlier we can get involved, the better your shot is at turning the case around in your favor. The biggest mistake people make is assuming the denial is the end. It's not. It's just the start of the next step in the fight, like I said. We just covered what to do if the insurance company denies your car accident claim in Georgia. But do you know how much your car accident settlement is really worth? Well, check out this next video where I dive into how you can know the real value of your injury settlement. We'll see you over there.